Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. All right, well, welcome back, everyone. Keith Fuicelli here. Excited to have another episode of the Colorado Trial Lawyer Connection. And this episode is very special because I've got my great friend, Jason Jordan, on to talk about an amazing trial that almost made it to the end, but I guess sometimes things happen mid-trial and for the better, and you settle cases mid-trial. But Jason, thank you so much for appearing on the show. Welcome.
Thanks for having me, Keith, and it's good to see you, man.
Yeah, good to see you too. So Jason, before we jump in and talk about this case, tell us a little bit about yourself. How did you come to Colorado, and are you the kind of guy that always knew you're going to be a trial lawyer?
Okay, so let's start with Colorado. So basically, my parents moved to Colorado from New Jersey when I was a junior in high school. And I was convincing enough to allow them to let me stay back in Jersey and live with a friend of mine for my senior year, graduate. And they got wind of some of the things I was getting involved in. So it was like basically graduate, 2 days later, you're out. So I always like to say 2 days after graduating high school, I moved to Colorado. But that was the reason why. And I've been here pretty much ever since, other than law school out in San Diego. So I've been here about 27 years and love it and started my practice here. But did I want to always be a lawyer? It was always in the back of my mind, yeah. But doing this type of law was one of those things that I never even, it's like going down in the legislature. Like half of them don't even know what we do. Like I really didn't, I was so naive going into law school. I really didn't know what, I hate the term personal injury lawyer, but like a trial lawyer, what we do and who, and, the idea that you can fight David versus Goliath and, really help an individual person through a horrible time in their life and make really good money doing it. And once I got exposed to that in an internship in law school, it was just off and running. I mean, I worked full time in that law firm. I got the little case notes, little, summary books of all the big ass books in law school and just kept my outlines ahead and studied to pass and started my own law firm right out of law school because I already had been working in a personal injury firm, for 2.5 years. They wanted me to stay in San Diego, take over a guy's practice. The firm was Hydane, Rotten, Ortley, and Dave Hydane really mentored me, still a good friend. They offered to open up a satellite office for me here in Colorado, and I decided I'd turn that down and just give it a run on my own. I was young, aggressive. I had one kid, one on the way. My wife thought I was crazy. I got a job offer from Godin and Beatty for like $55,000 a year.
Yeah.
She was begging me to take it. I turned it down. And within the first 4 months, I think I hit like a $400,000 case. And she was like, high five, you made the right choice. And then from there, it just kind of took off.
Yeah, I can remember back then because you and I actually knew each other right around that time because I was always so impressed that you started your own firm literally out of law school, hit the ground running, and frankly have had nothing but success since. So let me ask you this question. Anyone out there who's thinking about starting a law firm, maybe they're in law school and they know they want to do this work. Any advice you've got for them?
Yeah, I think first of all, you got to trust in yourself and you have to really have the confidence and the knowledge, right? I mean, I get young lawyers calling me up, asking me questions sometimes, and I'm not trying to be a jerk, but I'm like, the lady that answers my phones up front knows the answer to that question. Like maybe you need a little bit more experience before you go off on your own. But I also, I'm not one of these people where I try to oversell myself in one way or another. I'll admit I had a unique situation where my parents had a home here. My father took a job up in Idaho and I had a wife with a kid pregnant with another, and I had a home office. I didn't have to pay any rent. So, I had some things unfold for me it gave me the opportunity to say, okay, I can try this. And I had a little bit of a buffer, a little bit of a safety zone, but I just took full advantage of it and I went full steam ahead. So I think, it's important to, recognize, I read something the other day, I believe in luck. The harder I work, the luckier I get. And it's the truth. But if you're trying something like that on your own, I think you better have a lot of experience or at least know enough. And a lot of times I think some of the most successful people are the ones that know what they don't know. And then they go and get the information that they don't know. right? I mean, you start to try to really deduce what is it that I'm missing? What is it that I need? And lean on. What I found was really interesting to me was picking up a phone and calling a lawyer who was more established than me, much more established than me, and asking for advice, and them actually wanting me to be successful, actually giving me advice. Like a rising tide raises all ships. I didn't think I was going to get that type of um, response. So I remember Todd Travis was a big mentor of mine when I was younger in my career. I called him so many times. I think one day he said, "You just need to take the professional liability code and just leave it in the shitter. And every time you're in there, you just need to open it and read it and stop worrying so much." Because I was like so scared I was going to make a mistake. But so I think having the courage and the confidence in yourself and making sure that you've got a pretty good knowledge base to start from, and not be afraid to reach out to other attorneys out there and ask for help. And when you need to, co-counsel cases. I mean, I had a huge case that I wound up co-counseling years ago with a lawyer in town, probably 2007, when I was like a first, second year lawyer, second, third year lawyer. And it was the first time I sat through like a really long 30B6, a case with like 52 depositions. It cost hundreds of thousands of dollars. And it was like an eye opener. It was not an easy case, but it was like, I got excited, it got me going like, okay, I can do this. So I think, co-counseling it's always an important thing as well when you need to. But
Let's talk about
I just, I don't,
let's talk about that
go
for a
ahead.
second, because one of the things that I think is so impressive about your firm, and so we fast forward now, I don't know what, 15, 20 years you've had your firm.
Almost 20. Yeah. Yeah. Close.
20. So you go from hanging your shingle to now having one of the most badass firms for sure in Colorado, nationwide, trying cases throughout the country on a very, very high level. And one of the things that I'm so impressed with your operation is the team that you have in place and how you work up cases before you step foot into the courtroom. So, talk to us a little bit about what the listeners can hear about how you and your firm investigate cases.
So I think there's always, when a case comes in, first and foremost, the vast majority of our cases, and I haven't counted recently, but the last time I did, maybe a few months ago, it was like 85% of our litigation cases are co-counsel cases, right? They're law firms that bring us cases. So they've already come with some work done on them, and they've already, whether it's good or bad, or whether there's things missing that we need to kind of fill holes or whatever. There's always going to be an investigation in terms of like, okay, where are we? What do we have? But if you're talking about a case that just comes in the door and straight up looking into investigation, like we were talking before we started filming about a case where I know it's going to be heavily decided upon based on the EDR data that we're going to be able to pull from those vehicles. Well, I'm trying to figure out exactly how I can do that and how quickly I can get that done. But generally speaking, I think we start with what kind of case is it? Obviously, if it's going to be a products type case, we do a lot of product liability. That's in Ann's wheelhouse. So I'm going to defer to her, and she's going to kind of take lead on the steps that we need to do to get this thing lined up, right? Get the vehicle, get it secured, do as many interviews as you can before you let the other side know, because GM or whatever is going to send 50 investigators down to that area and start getting affidavits to try to secure a venue that's better for them, right? It would be inconvenient for us to travel and da 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 da. We try to do the opposite, right?
So, let me stop you. Because a lot of people that are hearing this might not have any idea what you're talking about. So, talk to us a little bit about venue, product liability, and what you mean when you say GM is going to send people down to get affidavits to try to secure a favorable venue.
Yeah, so like I'll give you a case I had about 10 years ago against Hyundai. It was a fatality case. It was terrible. Basically, as the car went off side of, like, it was on 70 eastbound, as it went off the side into a ditch, and when it did, the front right triggered the torso passenger bag, which, crazy design. The cable went through the door, and then there's a giant hole inside the metal panel of the door that the cable runs through to the handle of the door, right where the torso bag is. So when the bag goes off, it pushed on the cable, the door opens, and this poor 19-year-old girl, as the car is rolling, is now strapped to the outside of the car with the seatbelt, wrapped around her as it's rolling, and it killed her. But it happened in Colorado. The vehicle was manufactured partly in Illinois. She bought it in Illinois, right? It's not going to be, she died on scene. I mean, they flight for life, but she died in the helicopter. It's not going to be a case heavily intensive with respect to medical experts, right? Or even the EMTs or the police officers that show up to the scene. But we know what the defense is going to do. They're going to go out there and they're going to get their investigators to sign, get as many witnesses as possible to sign affidavits about how inconvenient it would be to travel, et cetera, to try to keep it in a venue like here where there's a cap on wrongful death, right? And make it harder for us. Whereas we want that case in Cook County, Illinois, right? And we want to apply the law in that state. So what we'll do is we'll go out and do the opposite. We get an investigation started and we'll go out and we'll get the affidavit signed that say it's not an inconvenience for them to travel. And then also when we're arguing with the judge later, obviously this is not a heavily Colorado located witness intensive case. It's going to be back there where they are, right? And they've got experts all over the country, et cetera. So that's just one little side note that I think people that don't do products don't think about. I certainly didn't in that case until Ann told me, we'll pump the brakes. This is what we're going to do first. But in terms of investigating cases.
Yeah, let me interrupt you only because I'm thinking of myself. And how do I know if I'm dealing with an auto product case? Obviously, you have to have catastrophic fatality or catastrophic injuries. Is it the kind of deal where
Right.
anytime you have catastrophic, 8 figures in damages type of case that you need to investigate the product side of it? Or how can our listeners that do not live in this world that you live in know that they need to reach out to you?
I think that, yeah, it's kind of what you just pointed out, I think makes sense, right? So you have this horrific situation. Not to not get too case specific, but semi truck hits a family head on, kills both parents. There's 3 kids in the back, and they're all ICU for weeks, but they live young, 6, like 9, 11, and it just looks like guy blew a tire, right? And went into oncoming traffic, and it's sad. And there's going to be $1 million policy. Well, I get a phone call from a lawyer friend of mine in that state and says, I want to look into the tire and see if maybe there's something wrong with the tire. Well, we first isolate the vehicle, and we do it in a way with a good chain of custody, obviously, so there's no spoliation type issue later. And we just look at it, no destructive anything, photographs, whatever we need to do before we notify the other side and have the proposed protocols go back and forth between the experts to then determine how we're going to actually diagnose this thing. And phone rings and he calls us up and he's like, literally his words, this is fucking litigation gold. And I said, what? And he said, the tire 2 tires back was going to blow within 2-3 minutes the same way the one up front did. And it was 9 tires later off the same fucking assembly line. You have a great products case. And we were like, holy shit, just by looking into it, storing the vehicle, now all of a sudden the case has become something potentially much different, right? So I think there's always a need. I think you're right about saying 8 figures, because you're going to spend, we had a firewall case that we resolved in Oklahoma, maybe 8-10 months ago, a year ago, that we spent over like $870,000 in costs. These things are not cheap, right? And you got to remember too, for people who are watching this in Colorado, when we're very lucky to have that Supreme Court directive that says you get a trial date within 1 year of the date of filing. A lot of other states are not that way. You're looking at 3, 4, 5 years of litigation and that type of cost you're carrying for a long time. And they're high risk. They really are very high risk cases. So you better know what you're doing and you better be highly selective in terms of the ones that you take. But yeah, I think anytime you have something that has that type of damage and that type of injury and something questionable like that, where it's not like, hey, they just blew a stop sign, you know what I mean? I think, yeah, it's obviously well worth looking into.
Got it. So obviously people Colorado or whoever's listening to this, they can reach out to your firm, Jordan Law, and you'll at least be able to give an initial screening and give some guidance on potential next steps.
Right. Absolutely. We do it all the time.
All right.
Yeah.
So let's talk about, I had the great pleasure of watching some of this last trial on CVN. Fascinating case. So if you could just give the listeners a little factual background of what happened.
Yeah. So our client, um, uh, this man, Matthew Jones, was taken early in the morning, I believe around 5:06 a.m. via ambulance to St. Mary Corwin's Hospital down in Pueblo. It's a Catholic Health Initiative hospital with basically gout. He had swelling in his legs and had some issues going on. He's taken in. Originally, he's a little bit confused, a little bit combative, not physically, but more kind of like not wanting to answer questions. And they put an IV in him and some other things. And then he basically just wants to go home. He wants to AMA. He's going to leave against medical advice, and they allow him to do so. And as he goes to leave, he's walking through the front area and around some other areas, but he's just walking around, and then he just kind of stands in the front, and he's trying to get a ride, right? So they try to call a taxi. His mother had a shoulder surgery, couldn't come pick her up, said send the taxi and I'll pay when they get here. And they said, we don't do that. The hospital could give vouchers. I mean, this was all testimony you saw, right? They could give a voucher and send him home, but they took the position that, he wouldn't have used it anyway. They could have called the police, and they said, the police don't arrive for hours, so, this and that. But they tried claiming afterwards that he was ripping phones off the walls. He was this, he was that, he was belligerent, he was aggressive and threatening. And eventually, after about 25 minutes, 4 security guards just surround him, and they grab him and try to force him outside. Well, it's 19 degrees out. The sun's not even up. It snowed the night before. He's wearing shorts and a t-shirt. All right. And he, of course, resists. And he puts his foot up on the door. He winds up cracking his head. They roll him over into a prone position, and they get on his back, and they get a forearm on his neck. They're on his back for a total of about 3 minutes and 16 seconds, if I recall, and on his neck for about 1 minute and 34 seconds. A nurse comes out, puts her hands up, and says, this is looking like a George Floyd situation. We all know how that turned out. I don't like the color. I'm getting a pulse oximeter. And they stayed weight on top of him until she came around. By that time, he had lost consciousness, never regained consciousness, and died 8 days later. Like George Floyd, he had some substances in his system, right? He had methamphetamine, ecstasy, cocaine. He's 400 pounds. So of course they want to, try to paint him as this guy that's like this, trailer park guy. Their idea was to paint him in that type of a light, and paint him as being belligerent. I mean, I could not believe an opening statement when the defense lawyer said belligerent. Nick and I split the trial up where he was going to do the human side with the family and the medical, and I was going to do the guards and the liability. And of course, in our case, we did not file a civil rights type of a claim. We filed wrongful death, negligence, and we're going for felonious killing because we knew we had 2 former DOC trained guards, and we had 2 former Pueblo County Sheriff's Office 27-year, 24-year veteran deputies that were trained. And Michael did a masterful job in the depositions,
Rosenberg, you're talking
lining
about
this all up.
Mike Rosenberg?
No, Michael Harris.
Okay,
In our office.
got
Michael Harris. He did a great job going through all of their training, all of their experience. They know that they should not have done that, right? So my job was to get to, obviously, for the felonious killing standard, conscious disregard of a substantial and unjustifiable risk.
All right, let's pause real quick. Let's pause real quick because I know that some of our listeners may not be familiar with this. So first of all, felonious killing, no cap, no wrongful death cap at all.
Correct.
Same thing with the
Correct.
1983 claim, but talk to us just very briefly about the strategy decision on 1983 claim versus not. And then also, correct me if I'm wrong, but felonious killing is a decision made by the trial judge. It's a question of law. Did the judge make that determination for you, or would that have been done post-trial?
Great question. Civil rights that was ruled out pretty quickly with us. Not only just federal court, I actually like being in federal court. I have 2 federal trials next month. A lot of lawyers don't. That isn't the reason why. I think, number one, they were charged with homicide. So we've got felonious killing, right? Then they drop the charges, okay? But we knew from their backgrounds that we were going to be able to set up the conscious disregard. We knew from their training, right? Like we knew what they were
What's
trained
the standard?
with.
Give us the standard for felonious kill.
Right. So for felonious killing, for those that don't know, to be able to get to a felonious killing where the cap is blown, you have to be able to show that they consciously, or somebody in this situation, consciously disregarded a substantial and unjustifiable risk. So if you noticed when I was doing each one of the security guards, I was going through their training, you knew, right? And if you noticed, we focused on he was not agitated, he was not aggressive, he wasn't threatening. He wasn't interfering with patients. I did this with every single witness. And the first witness, Officer Ruff, was one of the most brutal witnesses I've had to do in my career, only because I had to watch a full 25 minutes of tape and walk through while he's just standing there. Well, how many times can you ask the same question? He's still not belligerent, right? He's still not aggressive. Would you agree? He's still not combative, right? Oh, here comes a patient. They're able to check in. He's not interfering, correct? And I'm trying to, I told the jury, I need to make sure the entire video is seen. Because defense counsel got up and said, and when he gets to this front of the desk here, this is where he becomes belligerent. And it's like, belligerent my ass. And I knew the testimony they all had given in the depositions to Harris was that he was not combative, not aggressive, until their one guard, Randy Villapont, put hands on him, and that's what escalated the situation. And they're trained in de-escalation tactics and verbal judo and all this stuff from their years at the Sheriff's Department and Department of Corrections. So I'm setting up conscious
All right, and
disregard.
let me stop you real quick, just for the listeners. Could you just educate us on this idea of de-escalation and what both, because the reason I want to go a little bit deeper on this, Jason, is some of us might have these sort of negligent security type cases that come in.
Right.
So what would be the standard that both security and police are trained to do in situations like this where they need to remove somebody?
Right. Generally speaking, it depends upon the risk involved, right? And that's why it's so important to show he was not a risk to anyone at any given time. So de-escalation should be continued, which is talking, right? They call it the verbal judo. Just continue talking. If you notice in the trial, one of the guards even said I took his sweatshirt off the thing and tried to have him follow me. Sometimes they'll follow you in a situation like that. Calling a taxi, calling the police. These are things that are all de-escalation, where you're not having to go hands-on and escalate the situation to a physical and combative situation. So if you go to a bar and it's a security guard, what's their training? I mean, it's going to be maybe a different question there. Here, we knew we had actually government trained officials in departments of corrections and in the sheriff's department. We knew every every year for 27 years, this guy had the same training, right? This guy had the same training for 24 years. So to get them to understand, and to go back to your question, that, if he's not threatening, there's no reason to escalate, only a reason to continue de-escalating, right? And that they even mentioned at one point, I got him to agree that a couple days before a similar situation happened, and they just ignored the guy and he got bored and eventually walked away, right?
One of the things that I thought was fascinating is the fact that these security guards were former corrections officers. It seemed like you were masterful in using that as a sword and a shield, in the sense that they had this training, but yet they're used to being in a prison, and a hospital is not a prison. And so you have to treat people differently. Was that something that you all had sort of strategically decided was a theme you were going to explore?
Yeah, I did, especially when in the deposition Michael took with Ruff, which was the first witness that we used, and this is the reason why we used him, is because he said when he did the interview, he was told by the supervisor at the time that he wanted his guards to be more like a SWAT team, and he wanted them to have sidearms, and he wanted them to be able to be nice guys, but to be able to flip the switch and go aggressive, which is in complete violation of all of their standards, right? And he himself said, I thought that was a little weird, but I needed the job. And then how many times he had told other guards, like, hey, this isn't a prison. I mean, these are customers. You got to treat them differently, including his good friend, who we spent 24 years out of his 27 years, Randy Villapano. He had to warn him multiple times. And he's the guy who does the escalation, who comes up and puts his finger out and says, you're out of here, and grabs him. And that's what escalates the situation. So that's why we started with Ruff, and that we were going to start with him to basically create and get the understanding that this was a situation that he didn't feel comfortable with. He even said to his friend Randy, I've had more physical confrontations in this hospital in 2 years than I did in 27 years in the sheriff's department. What the hell did you get me involved in? That's what he said to this Randy guy. So that's like, it's gold, right? Like, so that's why we started with him. And um, if you watch that witness, you'll notice in my preparation, I sit down with I use Dan Brewer quite often. Dan's great for my audio visual. And I sit down with Dan and I go through with that witness and with every witness, but specifically the first few that I'm going to do this with. And I know all the main points that I know I need to get that are going to be the big ones like that, right? That they're going to try to backtrack. Okay. They're going to be coached. They have to try to not say that again. And I got him page, line, queued up, ready to go, impeachment, show the video. So when I did the SWAT team thing and I said, when you had your interview with this guy, what was your recollection of that? And he was like, oh, he's very professional, this and that, and gave me this great story about how great he was. And then I played the video. And of course, he goes through SWAT team and this and that. And then I'm like, looking at the guy. And of course, every question after that, he's just giving it to me. I said, we can go back to your transcript on your depot if you'd like and play it again. And he's just giving me what I want. Right. So yeah, the strategy there was to start with that guard for that reason. But yeah, you would expect the hospital to be treating people differently and using de-escalation tactics much more than you would in a prison situation where you're dealing with rapists and murderers and such, Um, so that was part of our plan going into it for sure, because we needed to show the conscious disregard and then the substantial and unjustifiable risk, right? You knew this could kill someone. I don't know if you caught, I actually, with one of the guards, Castro, he was crying at the end. And I said, you would agree that's a substantial risk, right? I mean, death's about as substantial as any risk could get. Agreed. And he said, yeah. And I said, and he wasn't, as we've said many times, he wasn't threatening anyone until you guys escalated it, right? You would agree that was an unjustifiable action on the part of the guards. And he's literally just giving me the felonious killing standards, right? I'm just walking each one of them down the path. So we felt comfortable with that. Now, during the trial, Nick wanted to put the question to the jury and at least do a jury advisement question. And that was still up in the air.
Okay.
And
So no
he and I were going back and forth.
no pretrial determination, no motions for summary judgment on the felonious killing piece?
We did do that. We filed a petition to have the judge determine it beforehand. We also had filed a motion for punitives, to amend for punitives. And the court, in his order granting it, said, willful and wanton, it's a very similar standard to the felonious killing. So he was already indicating, because we had really, I mean, I had all the depot transcripts, in the petition to have the judge determine it pre-trial. But he was going to defer, which I knew he would. But in his punitive damage order, he did highlight the fact that they're very similar standards, right? And she sees a prima facie showing, at least, to give us the punitives in this case. So it was almost like a warning across the bow of the defense that it's very likely, if the evidence comes in this way, that he would find for felonious killing.
Who was your judge again? I should know that, but I don't have it in front of me.
Figa, Judge Figa in Arapahoe. And I got to tell you, he's just one of those judges you love to have.
Okay.
He calls balls and strikes. He lets you try your case. You might disagree with the ruling here and there, but at least, he's got a reason for it. I really enjoyed trying the case in front of him.
Great.
I thought he was great.
Yeah, it seemed like you all had a great time, a great demeanor, everything was moving quickly. Question I would love to hear a little bit more about. The thing that struck me that was so impressive about how your team handled this trial is how you humanized your client, who, from what some of the stuff I heard, hadn't worked in years, on methamphetamine. They really abused his wife, apparently, all this stuff about the domestic abuse coming in. Walk us through a little bit about if it was you or Nick, or how does it actually work in the trenches to really be able to tell this amazing human story at trial?
Right. So, it's interesting. So I made a video recently that was on Instagram talking about going to your client's home and getting to know them. And Nick was going to take the client. So he had a nice dinner with her and spent some time with her, not only in the past, but of course, right before trial. And, you get so many good nuggets that what happens is your client's not going to tell you a specific story because they might not think, probably don't think, that you care or that you want to hear that story because they don't understand how the trial plays out. Whereas that little nugget and that little story is what's going to humanize this person. I need to know that. That's why going to a home, going out to dinner, and having those long conversations matters because you get much more information than just, okay, he wasn't working, what can you say about him? He used to go to your softball games and make it simple like that. Here, the defense had two different instances. Okay. They had a 2011 instance, which they misread and they didn't get into uh, because we were able to show it had nothing to do with her, that they thought was a domestic violence incident. But it did have alcohol involved, and then he violated probation. So he did go away. He got violated. He went away for a couple years. And then they had the one incident in 2020 where, as you heard, he grabbed her jacket, whatever. But it was more about just talking about who he was when he wasn't drinking and how often would he be drinking. He had some older brothers and sisters that were bad influences that he would hang out with, and when he would, he would know, don't come home until you're sober. But it's sort of like being a fly on a wall. I mean, if you're a fly on a wall in my home, you're going to see some moments that you're going to be like, ones that maybe we're not that proud of as a family, right? It's in everyone's home. It's in everyone's home. So for them to pick one moment in 2020, basically, right? And some other issues that he had been dealing with, which was substance abuse and alcoholism, et cetera, which he controlled pretty well. He'd go 3-4 months without drinking, and then he'd go on a bender and not come home, et cetera. I think number one, with the substance abuse, there's everybody on that panel has somebody they know, someone they've cared about, someone in their family that has dealt with that, right? So it's not like you could just make him a throwaway because, okay, he was dealing with that. He was a human being. He was a human being who had great memories with this woman, and that was really easy to show. And then to have them try to, um, uh, take that one incident and try to paint him as that person, even with the methamphetamine and the cocaine and the ecstasy and the bottle of alcohol on him, and all of that. When we talked to the jurors later, they actually told us they did not like how they were defending the case and trying to paint him as some degenerate trailer park type person when, she really loved this man.
One of the things I loved is that the 90-10 thing I think I saw Nick say in opening, 90% of the time he's this great guy, 10% of the time he's not. And this was one of those, it was Super Bowl weekend, 10%. I mean, that really resonated with me as, someone who knew nothing about the case and just watching. I thought that was really
Right.
effective.
Right. And that's like the fly on the wall, right? Like we can all go into someone's home and find their worst moment and then say that's exactly who they are all the time. No, maybe it's like 1% of the time. So I think Nick did a masterful job with that. I thought he did a great job with the client on the stand and humanizing her and the family and the story. And I think also the way the hospital lied to her and um, told her he was all alone and he coded and fell and hit his head. And it wasn't until the cops called her 6 days later that she found out, no, he was in an altercation with 4 grown men that put him in that position. She had no idea. I mean, I think that also really amplified the anger for what the defense was trying to do and really helped that story. And it showed how upset she was, which really helped show how much she loved that man, right? That she had been lied to like that. It just hurt her so much. So it all kind of came together very well. And Nick is just masterful at, the human side of the story, trial by human. That's his method.
Talk to us a
Yeah,
little bit. I noticed that there was a press conference that you all did. I think, was that right when
yeah,
you filed the case?
yeah. I think it was the same day we filed the case. There was a press conference down outside the hospital down in Pueblo. Um, yeah.
And what are your thoughts on sort of when to do a press conference, when not? Any advice you have for listeners about pretrial publicity?
Yeah, I don't. I think it really depends on the facts of the case. I think it depends on, some people think it depends on the defendant, right? Oh, they're a big defendant. I mean, they're the Catholic Church. They get sued all the time. They don't give a shit about getting sued, right? Like, like when you're doing a product liability case against General Motors and you're like, look at these injuries, right? This guy's burned, I mean, all over, lost his arms and all this. And it's like, do you think that's every case they see? Because they cost $800,000 to litigate. It's not like your case is the only horrific case, right? So it's like some people just think, oh, it's a defendant, so it'll get my name in the news or it'll be in the news and it'll scare them. And it's like they're not scared of that, right? But I do think in this case, it was so similar to the George Floyd type situation. We knew there was a cover up that was basically going on, lawyers trying to interfere with people being able to speak with the police, with the nurse Betty Weber and trying to intimidate her. We knew that there was some really shady stuff going on that we wanted to bring light. It was really bad, and I think that was one of the real reasons why we decided to do it. But I've also found in times where it's like it doesn't move the needle one way or the other, right? So
So how was it? I think I heard you say that somebody else had the case before and brought you in to co-counsel this case.
yeah,
So how was it? How did this case how was it born? How did your client, how did her spidey senses go off that like something here is not right? Was it when the hospital changed their story 6 days later? She went and got a lawyer and it was obvious that something needed to be investigated. I'm just sort of curious how the case came
right.
to be.
It wasn't really the hospital that changed their story. Remember, the hospital said he coded by himself and hit his head. It was when the investigators, the sheriff's office called her and said, "We need to talk to you." And if you saw this in the trial, she said, "I think you have the wrong person." And they said, "No, you're Deidre Jones, right?" And they said, "Yeah." "And your husband's Matthew Jones?" "Yeah." And they said, he was involved with an altercation with 4 security guards, and that's why he's in a coma, basically. And she was like, "Wait, excuse me?" That's when she decided to look for legal representation. And she found an attorney down in that area, David Webster, great guy, former prosecutor. And David and I have been friends for a while, worked some cases for a while with Michael as well, and with Nick. And he gave us a call and said, "Look, this looks like, I mean, they were trying to, they had already started to run interference with the law enforcement, the investigators, and the story on the news was he's ripping phones out of the walls and he's aggressive and all this bullshit." So we knew right away, we wanted to get involved and get as much evidence as we possibly could. At that time, obviously, they were being charged, or the investigation was still going on. They were ultimately charged with homicide. So then, of course, as you know, your ability to get your hands on a lot of evidence at that point is going to get shut down real quick. So it was more of a waiting game until all of a sudden they just dropped the charges. And
Did they consult with your client about that? Like what was the story?
no,
What? Really?
no, yeah. I mean, think about it though. It's Pueblo County. You got 2 Pueblo County Sheriff's Department deputies for 27, 25 years that are being charged, right? And they look at him like he's on meth. I mean, I think they thought no one's going to miss him. So what? We can just drop the charges and let it go. I think that's really what they thought. Um, but it's a shame, really. But it also put us in a position to show the jury that, you know, I mean, they wanted to talk about it. The defense wanted to talk about it. Great, let's talk about it. You, the jury, you're going to be the only ones that are going to be able to actually hold these people accountable for what they did, right? They have their nepotism down there that let them off the hook. And frankly, guess what? Same with the judge and the felonious killing. He is the last one to be able to really hold them accountable when he sees all that evidence here in Arapahoe County, not down in Pueblo.
Right, right.
So, I mean, I think it actually, I don't want to say it helped us, but we definitely played into that to be able to show these jurors that, this was the last chance for Deidre and Matthew to actually have justice. And when you see the video, we walk through it and you show he's not belligerent, as they say. He's not tearing phones off the walls. He's literally just standing there until they assault him. That this is the last chance for justice.
So I am sort of very curious about the settlement piece of this. I'm assuming that you have entered into a confidential case went away, whatever we're allowed to say. Were there any pre-suit settlement negotiations?
Yeah, there were some.
Okay, are you allowed to talk about them or?
No,
Okay,
no, I'm not going to get into that, but they clearly were, it comes down to the cap, right? Like, it's easy to posture and say, we don't think you're going to get felonious killing. Well, we rested our case and they only had two experts the next day, and then we were going to close. And it settled during lunch right after we rested.
Okay.
It got resolved.
Understood.
Um, so it was nothing. I mean, there were some that went on, but it really didn't get very far. And then during the trial, um, it started right after the first witness. They started to, we started talking.
Yeah. Yeah. That's,
I didn't actually expect it to happen. I didn't think that it was going to happen. But I think, honestly, Betty Weber, the nurse coming in, talking about how they were throwing her under the bus. She was the only one trying to help. They had an HR file that blamed her, saying she lied. She needs to be reprimanded. She did all this bad stuff. She never said the George Floyd comment. And then they had a quality assurance separate investigation where they have like 5 people that admit she said it. So it's like HR job is to cover its ass. And that's exactly what they were doing, and trying to throw this woman. She's the only one trying to help them. Right.
yeah.
So it really, as the evidence was coming in, I think they knew it was not good.
Yeah.
Let's put it that way.
Did you get a chance to talk to the jurors afterwards, and what feedback did you get, if any, from them?
We did. I did not. My daughter was going to college, and I raced home, I got changed, hopped on a flight, met them out in Tennessee to go drop her off because I was going to miss the opportunity to drop her off at college. But Michael, my paralegal, Rebecca, David, they stuck around and they spoke with almost every juror. We had 2 alternates. They spoke with every juror but one, and they spoke with one alternate. The defense wasn't there, so it's more of a one-sided type of a conversation. But that's where we learned things from them, like they were not happy with how the defense was trying to portray Matthew and blame him and that sort of a thing, right? I mean, you go to a hospital to get care, not to get taken down by 4 dudes and killed, right?
Right.
I mean, it's so they were pretty upset about a lot of things in that case, to be honest. But yeah, we did get a chance to speak to them. Again, I wasn't part of that, so I spoke to Rebecca, I spoke to Michael, and got some secondhand information from them about how the jurors felt.
Well, what an amazing result for your client. I mean, obviously, it's just completely horrific what she went through, but through your efforts, life changing. That's got to feel good.
Yeah, yeah. I mean, there's, doing what we do. I love the cases where, like you said, life changing. I had a client that lost both his arms in a fire, and I was able to get a substantial amount for him, enough that he could get prosthetics to where literally connects to his central nervous system and he can feel and use his arms. I mean, I literally, and I, not me, Anne. It was a product liability case. Anne busted her ass. I think it was 57 depositions. I mean, it was a shit ton of money, and it was a lot of risk in a state that is not, I could have lost at trial. And I was able to get this young man, Anne and I were able to get this young man his hands and arms back. And when you see video of him using them again and smiling, and it's like, took him 5 years, but it's incredibly rewarding to know that you can use your law license to do that, right?
So talk to us a little bit, because I'm sure a lot of listeners, this is primarily Colorado trial lawyers, doing car crash cases and whatnot. What do we need to know about product cases? And when one comes through our door, obviously reaching out to a firm like yours that has the experience and financial resources, but what's the product liability 101 for lawyers that do car crash cases all the time?
Right. Well, first, let me say, we do car crash cases as well. I mean, we're not just doing, product liability all day long. We do car crash cases. We do a lot of them. We have Mike Rosenberg in the firm, who's just, one of the best, if not the top 1 or 2 in the state, in my mind, for bad faith insurance. And he's just absolutely a genius. So we do a lot of different things in our firm, but when it comes to products, it's kind of, you got to have a good sniffer, right? Like, you got to have a good, something else may be wrong here. Sometimes people, I think, just think horrible accident, there's not enough insurance, and they look at the car and they like, I'll give you an example. I had one where we actually did have unlimited funds from an insurance standpoint, and this is a long time ago. And basically, I had a college wrestling team from out of state that was coming through Colorado, and they had a coach driving, and they hit ice and went off an overpass and horrific injuries. And um, even though there was enough to recover, the father of one of the boys wanted to sue the car manufacturer because the seatbelt, when it crushed, I mean, it's rolling down a hill, right? When it crushed in, it pulled across the lap restraint and it shattered this kid's hips, and it caused such damage he can't get an erection. I mean, he had significant issues, and he was like 19-year-old, buff wrestler dude. Um, and I'm like, look, man, the car looked like it took a hit from a freaking bazooka. Like, what? I mean, what do you expect it to withhold? I mean, it looked like, I mean, I'm surprised everybody lived. You know what I mean? So it's like some people are reaching in some instances, but there are good roof crush cases. There are other products cases out there that you do want to have a good sniffer on, like in that tire situation that I explained earlier, right? There are other ones where, we have a case right now in California, Los Angeles, where the guy is driving a truck and he's on the highway and a car breaks down. It's dark spot of the 405, and he doesn't see the car and just runs right through him. Well, he's in the least model of that truck. Every model above that has the automatic braking sensing system,
Oh,
but they didn't put it in that one. And it's like they drive right through the thing. I got an incomplete quad and a death case, and it's like they don't usually like to litigate those cases for too long because it's just basically them being cheap, not putting in the that extra part. It's the lowest model, but every model above that has that, and it would have alerted the driver. It would have braked for him, obviously dropped off the speed, dropped off the impact, and allowed him a chance to go around the
are
threat.
those becoming mandatory through the federal government at some point in the near future?
It's interesting you say that. In 2006, they had a law was passed that required specific information to be, that's the minimum, in EDR collection, right, of data. Every year things change as you go ahead, and sometimes their defenses aren't, well, it wasn't required. Well, that's not always a defense. It's available. I mean, how many other manufacturers have this already, and are using it in their vehicles? So, yeah, it's changing all the time. In that particular instance, I know it was a later model vehicle, which is a problem for them. Later model, meaning it's a newer
Sure.
vehicle that should have had it.
Yeah.
But yeah, I think, like having a spidey sense that it's something went wrong here, and knowing to look a little deeper into a potential product, failure. But we get all kinds of things that are products cases. It's not just auto. Um, but
Let
yeah.
me ask you this. One of the things I'm very curious about is trial preparation, how people go about preparing for trial. So, talk to me a little bit about when you really start diving deep, and are you, focus grouping? Are you using, focus groups to do mock voir dire and opening? How do you all go about preparing for trial? Because obviously you are masters at it.
So it's a great question. So if I am running my own focus group, which I rarely do anymore, I obviously will take it as an opportunity to voir dire, right? And I'll tell people this too. If you're going to do it, get like 40 people in a room, right? Like I've spoken to friends of mine that I'll say every Friday I'll do one with 7 people on the phone just to get tidbits of information and do it over the phone. I find it fascinating. It works for her. But I'll do sometimes 40 people in a room, and I'll do voir dire, and I'm doing it to practice voir dire. Okay. And I'm trying not to let them know what side I'm on, but I'm also trying to say, we're going to break you up into groups, because there's going to be, out of those 40 people, I'm basically going to get like 3, 4 different focus groups,
Okay.
right? And separate them.
Yep.
But I'm going to get one of those groups are going to be filled with nothing but people that would clearly never make it on the jury. So they're not influencing the people in the other groups. Okay.
Hang on, let me stop you because I'm fascinated by this. Procedurally, how do you do this? You get 40 people in a room, you separate them into groups, and then are you using video monitors? How are you then
Right. Yeah. So like
presenting the evidence?
downstairs in my office, we can hold up to like 60 people in that conference room down there. I'll rent it out for the day. We'll put 40 people in there. We'll put up a presentation, get it all ready to go, and we'll practice voir dire with them. And then from the knowledge I'm getting, you're group A. Well, group A may be the one that I'm just saying I'm disregarding. I'm not just going to abandon them and let them feel abandoned. But like when they deliberate and I put an audio recorder, they're not getting an audio recorder. I once had one time where a woman came out of the room and she goes, "That man is so unreasonable. He would never be on this jury." And I'm thinking, lady, neither would you. That's why you're in that room. But so sometimes I'll use it as an opportunity for voir dire. But I pretty much at this point know how I want to voir dire a case. I love doing voir dire. I mean, I really do. I've learned a lot from Nick over the years as to how to just be so much better at it. And it really is a good time. Like I'll tell you, clients or the jurors walk in trial, and we've got on this last one, and we've got like, I don't know, 50. And he just leans over to me and he says, "A lot of souls right here that need love." And I just thought to myself, like just setting the tone for himself because he was going to do the jury selection of voir dire. He talks to me about it all the time. People get up and they talk about it as like, I got to find the enemy. I got to find the
Yeah,
bad
yeah, yeah.
enemy. It's like, no, man, these people are human beings who come with their own stories, their own life, baggage, and that you truly are trying to get to the bottom of whether or not they would be a good juror. And if you treat them that way and treat them with love and respect and be honest with them about that, you're going to get a very good jury, at least get good responses to be able to make a good decision. Whether a judge is going to give you the cause or not, that's another story. But typically, I actually will outsource um, my focus groups to some other people that I've been using across the country that are not cheap but very very good, and I get a lot really good information from it that helps me on these larger cases. That helps me kind of prepare and know how I want to frame my case. From the trial prep standpoint, it really is this collaborative effort between who's doing what. From paralegal, I've got great paralegals and setting up trial exhibits and figuring out what they're stipulating to, which witnesses that we want to get in what order. Obviously, if they're not going to admit or into evidence or not going to stip to this evidence, I might need this witness first to be able to get this in. So it changes the order of not only witness but how I'm telling my story. Um, so you got to kind of figure that out as well. But then it's just sitting down, like and spending time together. Like sometimes we'll VRBO a house. We'll go up to Montana with Nick and just one of his places up there. We'll just camp out and just spend a week or two and just, I mean, literally going through the entire case and figuring out every little detail that we need, and a lot of the details that we don't need, and witnesses that we don't need, and all of a sudden shortening the trial by cutting witnesses out.
Let's talk about that because that's been a new sort of uh, something I just firmly believe in, the Joe Freed, less is more, just like trying to go in and streamline it as much as you possibly can. And here you have the trial that I watched, most of. First of all, the direct of your client was not very long, and the entire trial, would you
Right.
rest in 3 days or something?
It was Thursday, but we didn't start trial till we opened Tuesday morning
Right.
because voir dire was all
Yeah.
Monday. So yeah, you could say it was like 3.5 days, right? 2.5 days, or about 3 days. Um, so yeah, I know what you mean, and I agree. Less is more. I try to always slow myself down, but I want to get through my evidence quickly and succinctly, and I want not to bore the jury. Um, I think that's very important. I think it was tough for me in this case, like I said, with the first witness, 25 minutes of having to go through that
Yeah.
video. But then when I have the other guards, you see how much quicker I am with them, right? Because, okay, you saw the video. You would agree with fellow officer Ruff that he was never combative. He was never this. He was never that, da 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 da, until Randy laid hands on him. And that's when he escalated it, right? And your training, you had this and that and that and that. And before I know it, I get him to say to me, yeah, it was unjustifiable what we did. He's crying. And I said, do you want to apologize? And he's literally looking at my client, apologizing, crying, and no further questions. I was done in like 22 minutes.
Right.
You know what I
Yeah.
mean? It's like I got what I needed and I didn't do it in a nasty way or a too fast of a way like I didn't care. I just got the information that I needed and don't belabor the point. Um, I think that's uh, I think it's important, especially when you're on the winning side, right? Like when things are going well. I think it's you don't want to bore the jury, and you want to get them up there and get them off. I think that's an important part of it. But when you're dealing with complex stuff like product liability claims, there's an education part to the jury, which is kind of like what that video was, although a boring one. That takes a little bit longer.
So I think the last question I've got is, could you talk to us a little bit about how you prepared your client for trial testimony and cross-examination? Because boy, she was wonderful, so lovable on the stand, and you could tell the defense was trying so hard not to be mean, but she just
Right.
did wonderfully. How'd you all go about prepping her?
Right. So one of the things, like I said, Nick taking her out to dinner, he did that alone because he just wanted to be that bond between him and her. Uh, but what I typically do is a number of things. One, and I would recommend this to any lawyer out there that's going to go into trial. Go into it on a Friday when you're setting up. You got your audio visual, you got your paralegal calling, getting time from the clerk when they could get in there to set up audio visual and get everything set up. Bring your client in. Have them go sit in a juror seat. Have them go sit in the witness chair. Have them go sit in the seat that they're going to sit in next to you during the trial. Get them familiarized with the courtroom. Get them comfortable because Saturday and Sunday is going to be the most anxiety ridden time of their life. They're going to come in there shaken, right? But if you take them there beforehand and get a feel for what those jurors, there's only going to be 6 of them in here, right? A 7th with an alternative, just the judge up here. And there's going to be the guy that deposed you over here. And there's going to be us over here. Go sit in the witness chair, right? And you're going to look at them. When I ask you a question, I want you to look over at them. Don't answer it to me, answer to them, and you can kind of walk them through that in the courtroom. Number one, you're helping take away a lot of that stress and anxiety from them. Okay. With respect to direct examination and cross-examination, I've always said direct examination is one of the most scariest things for me, unless it's an expert, because I never know what the hell's going to come out of my client's mouth, right? Like even no matter how much you prep them, you never know what they're going to say. With an expert that's been doing it a while, line them up and just let them go. Ask them an open-ended question and let them go. And if they're good and you trust them, you're fine. Whereas cross, you're in control. You can lead all day long. You're controlling what's going on in the courtroom. Um, in this particular case, how are they going to cross her? They can't really go too hard on her, right? They're going to try to talk about the DV stuff and make it sound like, to help devalue the overall relationship, that there were issues in that relationship, et cetera. And we just wanted to talk about the fact that, let her answer it honestly of like, he was my everything. I mean, and that's what she kept saying. I mean, I loved him, with all my heart. And I knew, the 90% guy was the guy that I loved being around. And the 10% guy knew stay at your mom's house, until you're ready to be sober and come home. But we definitely work with our clients quite a bit with cross. I've even done, I had a case years and years ago down in Douglas County where my client was not very good. And I mean, he was just not good, not good. A nice guy, really
Yeah,
nice
we've
guy,
all had those. We've
but
all had
just
them.
just unreal. So I hired, or Peter Weinberg, right? So I hired Peter, and I'm like, Peter, I got a problem, and I'm like, here's what I want you to do. I got a friend of mine who's an old defense lawyer, and I'm going to go use a friend's mock courtroom, and I want you to go down there and watch, and I'm going to have him cross-examine him. And he's texting me. He's legitimately the worst witness I've ever seen in my life, and I'm like, God damn it! And that's why we're trying this case, right? They're offering me shit money. And I'm like, all right, like we're gonna have to figure this out, right? So we worked with him, and honestly, I had to sit him down and just tell him, a jury's not gonna like you. A jury's not gonna like you because you do this, you do that, and you do this, right? And we went through and we worked with him consistently, and we said we're gonna make you. He worked on a space project, right? So I said we're gonna make you the pocket protector guy. That's what I'm going to make it, right? You're going to be the nerdy guy so if you kind of go off on a trail a little bit, it's okay. And I'm going to set it up that way in opening about it kind of, you're a little quirky kind of guy. You'll see, this is what he does for a living, not all of us are cut out for that job, et cetera. And the defense lawyer tried to get him popping so much, and he did not do it. And then he even cracked a joke back that the jury was busting out laughing, where he said, and you were doing testosterone therapy for hair loss, because he was bald. And he goes, yeah, looks like you lucked out in that department, huh?" And the jury was laughing their ass off. We knocked it out of the park. We got like 8 times their last offer,
In Douglas
and
County, and
it
that's
was
great.
yeah, in Douglas County. And it was all just because of the fact that we recognized we had to put time in with the client, and we had to really, prepare this guy for what was coming and how to handle himself on cross. So it's a great question. I mean, it really is. And I think every case is a little different, but getting to know your client, I really recommend getting them in the courtroom so they can actually get a feel for it, and they're not as, if they don't know what to expect, these people see on TV shows, right? These CSI,
Right.
they're going to get ambushed on the stand, and they're going to shit their case right there on the stand in front of everybody and embarrass themselves. And it's like, it doesn't work that way, right? So you get them to see what it really is. And now you can calm them down. They're going to listen a little more. They're going to be a little bit more, approachable, and they're going to respond better on the stand.
Yeah. Well, I think that brings us to the end. And Jason, thank you so much for taking time out of your very busy schedule to chat with us. I have learned so much and am truly inspired. I'm so grateful for the result you had for your client, because I'm telling you, just from what I watched, I really felt that connection with your client. And I'm sitting here watching a trial on CVN. I'm not even in the courtroom. So that power of
Right.
that trial by human and what Nick and you all did is just masterful. So thank you again for taking the time to speak with us. And we'll catch everybody on the next episode. And Jason, I know you've got a couple more double set next month. So best of luck coming up to your many
Thank you.
adventures. And thanks everybody for tuning in.
Thanks for having me, Keith.
Thank you for joining us. We hope you've gained valuable insights and inspiration from today's Courtroom Warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.